Most of the states now have a good statute. The real big difference is there's a few post-birth states. For instance, I'm licensed in Texas, also California as well. California is a pre-birth state. So after your baby's born, there's nothing else for the law office to do. We're done, you let us know you have your baby, you put your name on the birth certificate, you get the bracelets, you're done. In Texas, we still do everything pre-birth. Even when we work with a post-birth state, we're still going to do it pre-birth, meaning we are going to get a court order that says the parents are the parents, right? But in a post-birth state, we have to send another document to the court that lists the place where the baby's born, their birth date, and their name. In Texas, there's nothing else for the parents to do. They still act like they're in California, right? They can put their names on the birth certificate right away after their baby's born. But post-birth state, there's usually just more work for us. So we petition the court, and we do this and we start this process typically at the end of the first trimester. I know it seems like that's a lot of time, but we have to get a declaration from every attorney involved, from the parents, the surrogate, her spouse, the doctor. In California, sometimes that paperwork is 100 pages. So it's a lot of work for our staff. So we have to do that and start it at that time, like the end of the first trimester, right at the second trimester, because we want that judgment of parentage certified by the court, and we want to send it to the hospital before the baby is born. And we do something that I assumed every law office does, but they don't. We actually find out who the contact is at the hospital. We send the intended parent's name, the surrogate's name, the agency contact, and all the attorneys, because we really want no surprises when the parents come. We want them to be able to see their baby being born if they can, and then to enjoy that time, because it's incredibly special. So I tell everybody who asks me that that's a movie. The surrogate doesn't want to keep the baby. She has her own family. It's really important when you pick a surrogate, and typically she has not only she's given birth freely, uncomplicated, but she has her own children at home. She has her own family. So that does not happen, right? We get a court order that says she's not the parent. I've had surrogates who I've represented call me up and go, okay, where's the document? I'm waiting. Where do I sign? Because I don't want this baby, right? She doesn't want the baby, right? But, okay, let's say, for argument's sake, that she does. She doesn't, but let's say she does. It would be a felony, because when she signs that contract, she's presumed not to be the parent, and she's stating her intent not to be a parent. She's had an attorney. The intended parents have had an attorney. The intended parents are the parents. They have a stated intent in that contract. So if that happened, it's not. But it would be a felony, she would be arrested, they would get the baby.